Dear viewers, in this lecture I am going to explain about right to freedom which are enlisted in the Constitution of India. What do you mean by freedom? Generally, freedom is having the ability to act or change without constraint. Something is free if it can change easily and is not constrained in its present state. It is associated with having free will and being without undue or unjust constraints or enslavement. Freedom is an idea closely related to the concept of liberty. Equality and freedom or liberty are the two rights that are most essential to a democracy. It is not possible to think of the one without thinking of the other. Liberty means freedom of thought, expression, and action. However, it does not mean freedom to do anything that one desires or likes. If that were to be permitted, then a large number of people will not be able to enjoy their freedom. Freedoms are defined in such a manner that every person will enjoy his or her freedom without threatening freedom of others and without endangering the law and order situation. Freedom means absence of constraints. In practical life, it means absence of interference in our affairs by others. Others means that may be other individuals or the government. We want to live in society, but we want to be free. We want to do things in the way we want to do them. Others should not dictate us what we should do. So, under the Constitution, all citizens have the right to freedom given in Articles 19, 20, 21, 21A and 22, and with the view of guaranteeing individual rights that were considered vital by the framers of the Constitution. It is a cluster of 4 main laws. Article 19 protects 6 rights of freedom. Article 20 gives protection in respect of conviction for offences. Article 21 gives the right to life, personal liberty, and the right to die with dignity. Article 21A gives free education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Article 22 protection against arrest and detention in certain cases. The Constitution also imposes restrictions on these rights. The government restricts these freedoms in the interest of the independence, sovereignty, and integrity of India. In the interest of morality and public order, the government can also impose restrictions. We will see in detail. Article 19 is available to citizens only. It confers 6 freedoms upon citizens of India. Freedom of speech and expression, assemble peaceably and without arms, form associations or unions or cooperative societies, move freely throughout the territory of India, reside and settle in any part of India, practice any profession, occupation, trade or business. You should remember that every citizen has the right to all these freedoms. That means you cannot exercise your freedom in such a manner that violates others' right to freedom. Your freedoms should not cause public nuisance or disorder. You are free to do everything which injures no one else. Freedom is not unlimited license to do what one wants. Accordingly, the government can impose certain reasonable restrictions on our freedoms in the larger interests of the society. We will see one by one. Article 19(1)(a), right to freedom of speech and expression. It is the right to express one's views openly and freely without any fear through oral means, written means, electronic media, broadcasting, press, etc. In modern times, it covers blogs and websites too. Freedom of speech and expression is one of the essential features of any democracy. Our ideas and personality develop only when we are able to freely communicate with others. You may think differently from others. Even if 100 people think in one way, you should have the freedom to think differently and express your views accordingly. You may disagree with the policy of government or activities of an association. You are free to criticize the government or the activities of the association in your conversations with parents, friends, and relatives. You may publicize your views through a pamphlet, magazine, or newspaper. You can do it through paintings, poetry, or songs. However, you cannot use this freedom to instigate violence against others. You cannot use it to incite people to rebel against government. Neither can you use it to defame others by saying false and mean things that cause damage to a person's reputation. Right to freedom of press also flows from right to freedom of speech and expression. Freedom of speech and expression is subject to various limitations on grounds of sovereignty and integrity of state, security of state, friendly relations with foreign states, public order, morality or decency, contempt of court, defamation, incitation for an offence. Article 19(1)(b) is right to freedom of assembly peacefully and without arms. This right is subject to sovereignty and integrity of India and morality. Citizens have the right to freedom to hold meetings, processions, rallies, and demonstrations on any issue. They may want to discuss a problem, exchange ideas, mobilize public support to a cause, or seek votes for a candidate or party in an election. But such meetings have to be peaceful. They should not lead to public disorder or breach of peace in society. Those who participate in these activities and meetings should not carry weapons with them. Article 19(1)(c) is right to form association, union, or cooperative society subject to morality, decency, and public order. Citizens can form associations. For example, workers in a factory can form a workers' union to promote their interests. Some people in a town may come together to form an association to campaign against corruption or pollution. Such association or union can be formed for religious, political, social, or cultural objective. Right to form cooperatives has been incorporated under Article 19(1)(c) by 97th Amendment Act. Article 19(1)(d) is right to freedom of movement throughout the territory of India, subject to interests of scheduled tribes and general public. As citizens, we have the freedom to travel to any part of the country. It is to be noted that citizens have the freedom to move freely throughout India, although reasonable restrictions can be imposed on this right in the public interest. For example, to control an epidemic, restrictions on movement and travel can be imposed, as our government imposed lockdown in 2020 this year due to the spread of COVID-19. Article 19(1)(e), right to freedom of residence and settlement throughout the territory of India. We are free to reside and settle in any part of the territory of India. Let us say a person who belongs to the state of Assam wants to start a business in Chennai. He may not have any connection with that city. He may not have even seen it ever. Yet, as a citizen of India, he has the right to set up a base there. This right allows lakhs of people to migrate from villages to towns and from poorer regions of the countries to prosperous regions and big cities. Freedom to reside and settle in any part of the territory of India subject to reasonable restrictions by the state in the interest of the general public or for the protection of the scheduled tribes, because certain safeguards as are envisaged here seem to be justified to protect indigenous and tribal peoples from exploitation and coercion. Article 370 restricted citizens from other Indian states and Kashmiri women who marry men from other states from purchasing land or property in Jammu Kashmir. Article 370 is no longer applicable in the Union territories of Jammu and Kashmir and Ladakh from 6th August 2019. Article 19(1)(f). This article was deleted by 44th Amendment Act and has been inserted under Article 300A. Earlier, right to property was a fundamental right. Therefore, on account of violation of this right, a person could directly approach the Supreme Court. However, after the passage of 44th Amendment Act, right to property is no longer a fundamental right. Now a person is required to follow the normal judicial procedure upon violation of right to property. The same freedom extends to choice of occupations. No one can force you to do or not to do a certain job. Women cannot be told that some kinds of occupations are not for them. People from deprived castes cannot be kept to their traditional occupations. Article 19(1)(g) guarantees right to practice any profession, occupation, trade, or business of one's choice subject to interest of general public. So, there is no right to carry on a business which is dangerous or immoral. However, state can prescribe necessary technical or educational qualifications for entering into particular profession, occupation, etc. Moreover, state can acquire any business partially or even completely in the interest of general public. Right to information has been given the status of a fundamental right under Article 19(1) of the Constitution in 2005. Article 19(1), under which every citizen has freedom of speech and expression and the right to know how the government works, what roles it plays, what its functions are, and so on. The Right to Information Act passed in 2005. This law was passed by Parliament on 15th June 2005 and came into force on 12th October 2005. This law empowers people to ask for information about central state governments, including non-governmental organizations, which are substantially funded by the government. The law gives citizens of India the tools to fight against corruption. RTI gives people the right to hold the government and organizations substantially funded by the government accountable. The Right to Information Act gives citizens the right to ask for the information and decide based on the information received whether their constitutional rights have been met. This law arms individuals with information so that they can advocate for themselves. The basic objective of the Right to Information Act is to empower the citizens, promote transparency and accountability in the working of the public authorities, contain corruption, and make our democracy work for the people in real sense. It provides citizens the right to secure access to information under the control of public authorities in order to promote transparency and accountability. It is often held to be an effective tool to control corruption, makes government accountable, and curb the arbitrary use of power. The Right to Information Act passed in 2005 extends to all states and union territories of India excepting the state of Jammu and Kashmir. This act gives Indian citizens the right to access information about any public authority or institution, including non-government organizations substantially funded by the government. The main aims of the RTA Act are to provide clarity of information to the citizens of India, to contain corruption, and to promote accountability in the working of every public authority. What is information according to RTI? Information means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. This includes the right to inspect works, documents, records, take notes, extracts or certified copies of documents or records, take certified samples of material, obtain information in form of printouts, discs, floppies, tapes, video cassettes, or in any other electronic mode or through printouts. Who are public information officers, PIOs? According to this Act, public information officers are to provide information to persons requesting information under this Act. How do you request for information? A person can request information in writing or through electronic means in English, Hindi, or in the official language of the area in which the application is being made, along with the prescribed application fee. The application can be made to the Central Public Information Officer, State Public Information Officer, Central Assistant Public Information Officer, or State Assistant Public Officer, depending on the case. What are the penalty provisions? A penalty of Rs 250 up to a maximum of Rs 25,000 will be issued to any public information officer on the following grounds: refusing to receive an application for information, not furnishing information within the specified time, denying request for information in bad faith, destroying information requested, obstructing access to information. Article 20. As per Article 20, no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence. No person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. Article 20 guarantees to all persons, whether citizens or non-citizens, the three rights. They are protection against ex post facto laws. Ex post facto law is the law which punishes for what had been lawful when done. If a particular act was not an offense according to the law of the land at the time when the person did that act, then he cannot be convicted under a law which with retrospective effect declares that act as an offense. Even the penalty for the commission of an offense cannot be increased with retrospective effect. Thus, the meaning of the above two provisions is that so far as criminal law creates a new offense or increases the penalty, it shall be applicable only to those offenses which are committed after its coming into force, and cannot cover those offenses which have already been committed in the past. Protection under this article is available only for offences and their punishments under criminal law and not for any civil liability where retrospective law can be passed. Article 20 prohibits the conviction under ex post facto law only in respect of substantive law but not in respect of procedural law, as no one has vested right in procedure. Protection against double jeopardy. No person can be prosecuted and punished for the same offense more than once. However, if a person has been let off after prosecution without being punished, he can be prosecuted again. Protection against self-incrimination. A person accused of any offense cannot be compelled to be a witness against himself. In other words, an accused cannot be compelled to state anything which goes against him. By forcing him to witness against himself, the accused is assumed to have committed or been a party to the crime. The cardinal principle of criminal law is that an accused should be presumed to be innocent till the contrary is proved. It is the duty of the prosecution to prove the offense. According to Article 21, no person shall be deprived of his life or personal liberty except according to procedure established by law. Article 21 confers on every person the fundamental right to life and personal liberty. It is the most fundamental of human rights and recognizes the sanctity of human life. This article provides right to life and personal liberty except on the ground of procedure established by law. Over the years, this article has undergone a sea change, become the most important and fundamental right. The Supreme Court, through a liberal interpretation of the article, has derived a number of composite or inferred rights. Now, the article stands not merely for the right to life and personal liberty, but also the right to dignity and all other attributes of human personality. Those are essential for the full development of a person. That is why Article 21 has become the foundation stone of Part 3 of the Constitution. Let us see the evolution of Article 21. The Supreme Court and High Courts have been enlarging the scope of the article with various activist judgments. Initially, the phrase personal liberty was interpreted narrowly to confine the protection of Article 21 to freedom of the person against unlawful detention. In Gopalan versus State of Madras case, the majority bench of the Supreme Court propounded the view that by adopting the expression procedure established by law, Article 21 of our Constitution had embodied the English concept of personal liberty in preference to that of American due process of law, even though, according to the minority opinion of the bench, the result of such interpretation was to throw the most important fundamental right to life and personal liberty at the mercy of legislative majorities. The concept of personal liberty gradually began to liberally interpreted by the judiciary. In simple words, the right to freedom is just one of the incidences of right to life and personal liberty. So, whatever applies to right to freedom, in this case, the test of reasonableness applies to right to life and personal liberty. In the case of Menaka Gandhi versus Union of India, the court examined all the judgments in previous cases and observed that the expression personal liberty in Article 21 is of the widest amplitude and it covers a variety of rights which go to constitute the personal liberty of man, and some of them have been raised to the status of distinct fundamental rights and given additional protection against Article 19. So, this is the Article 21. Next, Article 21A. According to Article 21A, the state shall provide free and compulsory education to all children of 6 to 14 years in such manner as the state may by law determine. Article 21A declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only elementary education a fundamental right and not higher or professional education. According to Supreme Court, the right to life and dignity of an individual cannot be assured unless it is accompanied by the right to education. The right to education has also been held to be a part of Article 21 and by 86th Amendment Act of 2002. A new Article 21A has been added after Article 21. Accordingly, right to education has been made a fundamental right and has been deleted from the list of directive principles of state policy. Accordingly, the Government of India passed the Right of Children to Free and Compulsory Education Act 2009. This act seeks to provide that every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. Article 22 grants protection to persons who are arrested or detained. Our Constitution guarantees certain rights to the arrested person. The first part of the Article 22 provides specific rights to persons under punitive detention. Punitive detention is detention of a person after trial and conviction to punish him for an offence committed by him. These rights are the right to be informed of the grounds of arrest, the right to consult a lawyer of one's own choice, to be produced before a nearest magistrate within 24 hours of arrest. Further, the period of detention cannot be beyond what is authorized by the magistrate. It may be noted that aforesaid safeguards are not available to alien enemies and persons arrested or detained under preventive detention law. The second part of the article deals with preventive detention. In preventive detention, persons are arrested to prevent them from committing a serious crime. Preventive detention is detention of a person without trial for a limited period. When the state suspects that a person is likely to commit crime or is a threat to the security of the state, such a detention too is subject to some safeguards present in Article 22. These provisions are: first one, a person detained on the ground of suspicion shall be detained for a maximum period of 3 months. If the government seeks to detain the arrested person beyond 3 months, his detention must be authorized by an advisory body comprising judge of the level of High Court. In this regard, the Parliament is given the power to determine by law the maximum period for which a person can be detained on preventive grounds. The detained person must be informed about the reason of his arrest as soon as possible. An exception has been added to this provision that the state may withhold the reasons of preventive detention or such related facts if it considers that to be against the public interest to disclose. The detained person must have the earliest opportunity to present his case before the authority of law. Thank you.